All right, so on we are now to Chapter 3, the low and the high, presumption, power, and police expertise. This chapter starts off with the observation or the claim that the court is the territory of law enforcement. The territory where law enforcement essentially takes as its own, where it feels at home. We'll see by the end that that holds even when an officer is on trial. So the sense of the courts as law enforcement's territory rests on a foundational concept of us versus them that distinguishes police officers and civilians. And this gains expression in several ways. One of the most significant of these expressions, so despite statutes to the contrary, that formally strike down the requirement that victim testimony requires corroboration, is that in practice, police testimony functions as corroboration for, but also sometimes contestation of, victim testimony. So that in a sense, the jury will come to understand victim testimony in the light of police testimony, either for good or for ill. A feature of this authoritative position of police in trials is the police officer's potential to drift from fact witness. So an officer who was, say, the first responder who collected facts and so on, to expert witness. So an emphasis on the officer's experience, expertise, extra training, and so forth. Whether corroborating or contesting a victim's testimony, the authoritative positioning of the officer lends itself to the notion that victim testimony does not stand on its own. Officer testimony, yes. Victim testimony, no. And not just victim testimony, other witnesses as well. So it's not unusual, they note, for women facing chronic intimate partner violence to recant their allegations. This is a survival strategy, right? That if you recant the allegation of the person who habitually abuses you, then if you wind up going back into a domestic situation with that individual, it improves your chances for survival. This is the thinking. And it's what happened in this case, State v. Morrison. When this happens, prosecutors may treat the victim witness as a hostile witness. And so that means that they can treat them on the stand with a bit more latitude. In that case, then, they can rely on officer testimony to impugn the victim's testimony so that the case doesn't hang on the victim's now discredited testimony, but rather on the officer's valorized testimony. Key to this is the prioritization of officers' testimony as establishing their experience, right? So that the prosecutor at the outset will ask the officer essentially for credentials. So how long have you been on the force? Have you received extra training and so on? Things like this. This then will be kind of the setup or the framework within which further testimony from the officer will occur. Police testimony then gives careful attention to the methodological routine of responding to, documenting, and investigating allegations of assault. In a sense, this is part of what their authority rests on, is that they are methodical so that there aren't gaps in the investigation. It's not only then officers' testimony as such that has substantial weight, but also the reports that they produce in such cases. So they write, Hlavka and Mulla write, first reports are touted as the most reliable, in part because they are assumed to be free of social contamination by others, be they friends, family, or additional investigators and medical personnel. Excuse me. Oh dear. Okay. And here is where we learn a concept that will reappear, excuse me, in the chapter several times, that of the data double, which is a legal subject, not the victim herself, that is able to attest to the veracity of violence through time, long after the victim has decided whether or not she desires to participate in the criminal justice process. Right? So that even when you have a reluctant or recalcitrant victim witness, the data double, the reports that the officer first produces about the case, can do the work that the victim testimony would have done under circumstances when the witness is a willing participant in the process. Alongside the data double, another important development is how an officer can drift, is the word they use, drift from fact witness to expert witness. For instance, attesting to the facts that the officer found at the scene, but then framing them in terms that gesture toward the officer's expertise. So they give an example in which the officer testifying describes the witness testimony, the victim testimony rather, that the defendant battered her. Now, of course, it's unlikely that someone is going to describe what happened to them as he battered me. It's probably going to be something like he beat me or he assaulted me or something like that. So that the introduction of this kind of technical vocabulary already points toward this drift toward expertise in the case of the officer testifying here. So then the officer's testimony is not just about the production of facts, but is also a certain kind of performance of the mastery of routine aspects of responding to and documenting allegations, performance of expertise, of competence, of neutrality, and so on and so forth. This performance can give equal or greater credibility to the officer's testimony than to the victim's. So, Hlavka and Mulla write, this hierarchy of credibility attached to police testimony, even in cases where it contradicted reliable witnesses. While each police witness had walked the jury through the low policing work of routine report taking and bureaucratic practice, their collective performance as a consistent and authoritative force aligned with the political practices of high policing that entrenched the political power of the police. We can see then police testimony operating in these two ways, low and high. One is the role in a particular case, gathering evidence, responding to the scene, and so forth, while the other, collective, secures the authoritativeness of police testimony generally. Now, in this case, State v. Lopez, there is contradictory testimony on multiple fronts. The defendant, who claimed to be tickling, in the context of a hospital, tickling his nonverbal autistic daughter to try and sort of settle her nerves, and then checking to see if her diaper was wet. The witnesses who alleged the wrongdoing in the first place, but were also then not kept separate before and during questioning, partly on the basis of one of them being a non-English speaker, and so requiring the other to do the work of translation. And then the police whose account diverged from the witnesses' testimony about questioning them, whether it happened by phone or whether it happened in person. The schism between the officer and the witnesses provided the defense with the resources to discredit witnesses' powers of recollection, not because the witnesses were clearly mistaken and that could be demonstrated, and that the officer was clearly correct, but because Detective Liu had a symbolic edge in terms of his presumed powers of recollection and observation. the prosecution then was in a difficult position. On the one hand, then, it relied on Detective Liu's investigation and testimony, and so couldn't really argue that he was wrong, so that both low policing, the investigative aspects, and high policing, the general maintenance of police credibility, left the defense able to pit Detective Liu against the witnesses on their recollections of the interviews, whether they happened in person or over the phone. And then further, they could impugn the detectives' methods with the witnesses, right? Not keeping them separated, having the one translate for another instead of having an official translator. I believe those are the main points. Okay, so next, a version of events, State v. Lee. Here we get something comparable arising when officer testimony contradicted the victim witness's testimony with respect to how she got to the hospital and even to which hospital it was. So again, the defense was able to play on the victim's apparent uncertainty about specific facts, essentially saying, if she can't even remember how she got to the hospital or which hospital it was, how can we trust her testimony? And so Hlavka and Mulla conclude, these sorts of juxtapositions between lay and police witnesses during sexual assault trials uniquely situated the victim witnesses' powers of recollection and powers of observation as deficient. This then leaves the defense to emphasize potential procedural errors by the police, right? Because if you can compromise the police testimony, then the prosecution has not much left to rely on. In the next case, State v. Rafferty, something like the opposite of the previous two cases happened. Here, when relatives of the defendant tried during their testimony to undermine the testimony of the victim, who had been a child at the time of the assaults, the detective, shifting again smoothly between fact and expert witness, drew not just on the facts of the investigation, but also on her expertise based on her accumulated expertise with victim behavior to bolster the credibility of the victim's testimony. Something similar to what we saw in Chapter 1 with respect to Maya, also a child victim, and whose testimony then benefited from the kind of ordering work that the officer could do, and for the way that the detective could explain how problems of detail or sequencing or things like that, or not being certain when one thing happened with respect to another, how these things then can be reframed through the expertise of the detective as reliable testimony. Again, then, the point is victim testimony seems to be valid insofar as police testimony supports it. Having opened the chapter with the observation that the court was the territory of law enforcement, Hlavka and Mulla reinforced this claim by describing the show of police solidarity when a fellow officer was tried, convicted, and sentenced, and how the court itself tacitly acknowledged this territorial claim by just sort of allowing officers a latitude that would not be extended to civilians in terms of the quantity of police presence in the courtroom during the different phases of the trial, the slightly looser restrictions on their behavior, whether they could say quietly express their disagreement with what they were seeing going on in court. So that what would normally be tolerable, or a limit, I should say, for the court, was relaxed in the case of police, when police are in the gallery. They also note, though, that the prosecutors take some pains to maintain the idea of high policing, right, of the overall authority and competence of police by pitching this one officer who's on trial as a bad apple, and not therefore impugning the rest of an otherwise respectable department. The defense on the other side, though, tries to mitigate the defendant's culpability by saying that, look, he's just the product of a culture of corruption that pervades the entire department. So in a sense, it's not really his fault. He's a symptom of a larger problem within the department. So therefore impugning the not impugning, but compromising high policing in this case. Hlavka and Mulla reiterate aspects of high and low policing and how they contributed to producing the data double in this concluding passage. They say, police testimony often emphasized the routine nature of everyday police work, such as interviewing, report writing, and the use of various forms. The repetition of these procedures gave police testimony its consistency. The report was not simply a factual exhibit. Rather, it epitomized the officer's discretionary decision-making as he controlled what details were credible enough to make it into the official report. As officers testified, they not only revealed the routine measures taken in a case, but also mediated the data double of the victim witness. So then the attribution to officers of enhanced powers of recollection and observation sometimes conflicted with others' testimony, less credited because they were not seen to be endowed with these powers of recollection and observation. But their cultural and social capital on the basis of these enhanced powers lent them authority that civilians therefore lacked, which means that the police testimony had the potential either to corroborate victim testimony that jurors might not trust on its own, or to undermine competing testimony. So that again, I come back to the idea that not only could police produce this data double, but that the value or the veracity of victim testimony would be judged in the light of that data double and of police testimony, which would be sort of granted a default authority and a default veracity. That's all. Thank you.